great day, everyone.
Thank you for being here, Ms. Lee.
Thank you. Have a great day, everyone.
Thank you. Tab C,
You too, madam.
motion to vacate final order. Thank you. Tab C, motion to vacate final order 2025-04679. Michael Ruiz.
Good
If
afternoon.
present,
Good
please
afternoon. This
unmute
is
and
Michael
state your
Ruiz.
name
Can
for the
you hear
record.
me fine?
We can hear you, sir. Thank you. And commission for the record, the supplemental information. We can hear you, sir. Thank you. And commission for the record, the supplemental information was provided. At this time, this matter is presented to you as the respondent's motion to vacate final order on waiver and request for evidentiary hearing. Before hearing from the petitioner, Madam Chair, may we allow the Office of General Counsel to introduce any discussion that they may have regarding this matter?
Yes, please.
Thank you. Ms. White?
Madam Chair.
Yes, Commissioner Ketchum.
Madam Chair.
Yes, Commissioner Ketchum.
I served on PC on this, so I'm going to recuse myself.
Thank you, Commissioner Ketchum, because you as well, Madam Chair, served on probable cause. So we would still have quorum, Mr. Harris with Vice Chair Price, Commissioner Fitzgerald, Butler, and Barbara. So perfect.
sorry.
So Vice Chair Price, if you can take the proverbial helm. And then Ms. White, are you there for discussion, ma'am? Mr. Fortunis. Mr. Fortunis.
Yes, I am available. Yes, I am available. And this is a request to vacate the final order and allow an evidentiary hearing.
Right. And it was my understanding, Mr. Fortunis, that the Office of General Counsel opposed the motion. So I just want to make sure that that's the fact and state it for the record.
Yes, yes, for the record,
Thank you.
James Fortunis for the record, yes, we do object.
Thank you. Madam Chair.
That's you, Price.
She's
That's you, Price.
Ms. Price.
You
you're
are
muted.
muted, ma'am.
Sorry, apologies. Ms. Corona.
You are muted, ma'am.
Is this tab- Sorry, apologies. Ms. Corona, is this tab A? Correct?
This is tab C, Michael Ruiz.
Hold on.
Thank you.
Yep.
Hold on. Let me just.
Oh, I got the two of them. I got them backwards. Thank you. Hold on. Let me just get to that tab.
Of course.
Oh, I did this on the last person. Okay. All right. Mr. Fortunis, do you have something you want to say to us?
Yes, ma'am, Ms. Price and Commission. Yes, we do. We object to the request.
And
Okay.
Mr. Harris, since Office of General Counsel has.
And
objected-
Mr. Harris, since Office of General Counsel has objected, do we need to do anything special?
Well, you do. So Mr. Ruiz has done a very good job of properly submitting his documentation in advance, his motion, the exhibits there too. He got it all to you. I know you've read it all. Generally, you'll give him a chance to respond, to argue his motions. But you've read them, and in the interest of time, I hate to be the bearer of bad news, but I don't believe legally that you can grant him any relief today for legal reasons. The fact is, unlike the first case we had earlier today, we have a final order that was not appealed. Therefore, that final order is a final order. So the only way you could overturn it would be through the doctrine of administrative finality, which is that there has to be a substantial change in circumstances and a showing of public interest. That's a very hard burden. And I don't, in my legal opinion, that isn't met here. And the reason for that is because, as we talked about with Ms. Lewis, the last case, the remedy for this case, frankly, is reapplication. So the order is final. You could theoretically, if you all think he pled some substantial change in circumstances that did not exist at the time of the final order, and that it's in the public interest to vacate that final order, you could do that, okay? That still wouldn't give him his formal hearing, because independently, he waived the right to a hearing because he didn't respond within 21 days. So that is gone. The case law is very, very clear that essentially there's no such thing as equitable tolling in, there's no such thing as My fault. He can't have his reconsideration based on his excusable neglect. Excusable neglect doesn't exist in administrative proceedings. The only thing that exists is something called equitable tolling. And equitable tolling is you thought you filed it, but you didn't for some legitimate reason. The standard is an appellate court, you file in one district instead of the correct district, or you file with the circuit court instead of the district court. But you think you filed. In this case, he does make some significant arguments about the pre-AC stuff that he was lulled into this action there. But that wouldn't count for equitable tolling because the equitable tolling doesn't start until the AC is served. So there's the 21 days for that. And it's pretty clear from the record he didn't file within even close to 21 days. So you got a waiver hearing. So that means theoretically you could reconsider the penalty because he wasn't present. And so you could, in theory, you could do that. But where you would be is back to a legally shaky order that would be overturning the prior thing that you did. To me, administratively, the best thing to do here would be to immediately file a new application and get back in front of you and explain, make the arguments he's making now, which is some, he had some good mitigation in his arguments there, and had that been presented at the right time in the right manner, it may or may not have changed your mind about whether revocation is the right penalty. But he didn't, and we can't go backwards and undo what he didn't do. It just doesn't exist legally. But going forward, he could presumably present that information to you, and you could take it into account as a commission in deciding whether to relicense him. And if he should be relicensed, whether to license him as a sales associate or a broker associate or a broker, and to relicense him with any conditions that are necessary to protect the public. So things like that. And I think as the commission's legal counsel, that's my advice to you. I think that's the easiest way to proceed. I think it's the correct legal way to proceed. If Mr. Ruiz disagrees with that, he can seek to, he could appeal, he could try to appeal this motion on reconsideration, but the standard for that would really be astronomically high. Unfortunately, I hate to be the person that says no, because that's not really my job. But in this case, it is my job to tell you as your lawyer, I just don't think he has a leg to go forward on at this time in this posture.
So, Mr. Harris, thank you for that clarification. We do have a recommendation from the Office of General Counsel. Now we have your recommendation. Does any of my commissioners have any questions for Mr. Harris before we do anything? Mr. Harris, do we want to let Mr. Ruiz speak, or do we just go ahead and say no? What's the best?
Absolutely say you should definitely let him speak. You should absolutely let him speak. He may be able to argue something that I missed, but unless he's able to really overcome those presumptions, I don't think there's a whole lot of options here.
Okay, so
Madam Chair, this is Ms. Corona.
sorry.
This is Ms. Corona for the record. This is Ms. Corona for the record. I believe that Ms. White was muted when we were calling her. May I call her to see if she has any additional discussion before hearing from the petitioner?
Absolutely.
Thank you. Ms. White?
You sound very faint.
Ms. White, you sound very faint. Could you move closer to your microphone, please?
Yeah. Is this better?
It's better. Yeah,
Not much.
it's better.
Better? The only thing that I was going to say, which Mr. Hass has already said, that this case, he was revoked, and this case came on a motion for waiver. So as far as the department is concerned, this final order which was not appealed, we would object to vacating that order and returning it back to the department.
Well, I think from Mr. Harris's all right. Well, I think from Mr. Harris's recommendation, Mr. Ruiz, we're going to go ahead and let you present your commentary, and then we can listen to it, and then we can take a vote. So please proceed, Mr. Ruiz.
All of you, the commission, as well as as the chair. And I want to thank the time for allowing me to speak at this time. And again, also to Ms. Corona for having helped me to this moment today due to all the clerical issues with the notice of hearing that had confused everything for me to even get here to today. I wish to respectfully explain this very personal context of this matter and why I'm humbly requesting your reconsideration today. The sole complainant, Mr. Quinoir, is a dear friend of mine who I've known from our church's men's group, which I've led for over 15 years. And at the time, he was experiencing severe personal duress and facing foreclosure. And with my experience that I've been doing this since 1983, without ever having a complaint, I tried to help him short sell the property. And ultimately, I released the listing, and he sold the property without me even being involved. On October 18th, 2024, Mr. Quinoir, the complainant, formally emailed the investigator, copying me, stating, "I'm writing to formally request the immediate withdrawal of the complaint I filed against Michael Ruiz. I no longer wish to pursue this matter. I kindly ask for the case to be closed. I respectfully request you stop any actions against Michael Ruiz. My faith teaches me not to file a suit against a fellow believer. And so I respectfully request you to stop any actions against Michael Ruiz. Please confirm the necessary steps to formally withdraw the complaint." That was his statement. Despite this, just 4 days later, on October 22nd, I received and personally signed for an administrative complaint via certified mail, which left me confused since the complaint had already been withdrawn. Now, apparently that must have crossed in the mail, because apparently it was sent on the same day that he sent his email. From that moment that he withdrew, to my understanding, and based on Florida law, which protects the right to notice and to be heard, nothing further should have gone forward. Throughout, I have done everything possible to cooperate with the department, including quickly contacting your staff, appealing the order, providing documentation, and remaining ready for any hearing. And at one point, since I didn't hear anything, I contacted your department, and I spoke to, let me see here my notes. I want to be specific. Miss, I think it's Jasmine, Miss Bazan, where she stated that, let me see here, I apologize. Jasmine Batista, she confirmed everything that I explained to you, and then she sent a copy of an email to Miss McKenzie, Miss Paniello, and copied me stating, Joe Bazan did not forward the email to anyone on this case, and this email went unseen. The case final order has already been sent to the agency's clerk. And I've provided that email as an exhibit as well. And apparently this fell through the cracks. But there is no complainant. There's no one here complaining at this point. There's no allegations of public harm. And again, after 40 years as me being a broker with no disciplinary record, I'm here only because of an internal agency error, not for any wrongdoing. And from the beginning, there seemed to be errors where emails were sent to the wrong email address, and then also conflicting information from Andrew Litz, because when I was following up with everybody, I kept getting calls that there was a complaint filed against me. I didn't believe it. I thought it was spam. I thought it was some type of a scam. Eventually, I confirmed that it was, and it was Mr. Joe, same person that I spoke earlier, that I mentioned about the email, Joe Bazan. And when I eventually found out that he was legit, that it was from the DBPR, we confirmed that he was sending an email to the wrong email address, where his supervisor emailed me himself, copying me saying, "We noticed that an error made on our side," and he put it in underline, "while inserting your email address prevent our official communication." So again, I respectfully and humbly ask the commission to dismiss this case and reinstate my license and waive fines or costs that resulted from process errors beyond my control. The case should have not even gotten to that point. And again, throughout, I have been very proactive, as Mr. Harris has said, and I've done everything possible to cooperate with the department, including quickly contacting your staff and appealing the order, and repeatedly following up, providing documentation, and remaining ready to be heard. So I'm ready to provide more details on any aspect should the commission desire. So I just want to thank you in advance for your time and consideration, but I'm baffled by all this. For what I'm hearing, I hear the gentleman, Mr. Fortunas, I believe, stated that he objected. I'm not really sure why he's objecting or what the objection is. So I remain here at your mercy at this point, I guess.
And Mr. Reese, thank you so much. If you don't mind just standing by. And Mr. Reese, thank you so much. If you don't mind just standing by, I'm going to ask you just to listen in while I talk to Mr. Harris, Mr. Fortunas, Ms. White. They're both from our Office of General Counsel and the commission. So if you could just stand by and not chime in until we talk a little bit, okay? Thank you. Thank you for your presentation. Okay, Mr. Harris and Ms. White, it's your turn again.
Well, this is Harris. I mean, all of that may be true, and he has documentation to show it, and it is certainly a bad look for the department. But remember, number one, the statute is very clear that once a complaint that is legally sufficient is received by the department, in its sole discretion can decide whether to move forward or dismiss that investigation. In this case, for whatever reason, the department decided to move forward. That is 100% legal. It is unfortunate that there was so much miscommunication with the respondent, but that happened. Well, unfortunately, an AC was served, and it was properly served. That's a legal document. And again, I think the respondent has a lot of mitigation for that. And again, it's a bad look for the department that may have changed your mind. But he didn't respond within 21 days, and that's a legal thing. There's no legal ability for the commission to ignore that. So you had a waiver hearing. Okay, well, that's fine. He could have presented all of this at that waiver hearing, and you could have considered it. But for whatever reason, he wasn't at that hearing. Okay, you issued a final order. The law in Florida is extremely clear. You have 30 days to appeal that, and if you don't, it becomes a final service order. It is no longer under the jurisdiction of the commission. You've lost jurisdiction over that final order at that point. There's a little narrow carve out that's legal doctrine called administrative finality, which in extraordinary cases says that agencies can sort of go back to an order that's already final. A lot of times people call these reconsiderations, and we talk about them as such, but they're sort of really on the border but the order never really went final because they got the reconsideration in within that 30 days. And you all have tended, in order to be abundantly fair to people, have tended to give them that reconsideration. In the very first case, that fellow lawyered up, and the lawyer knew what to do, and he filed an appeal within 30 days, got on the phone with the appellate attorney for the department, said, hey, we don't really want to proceed with this appeal. If we can work it out at the commission, can we send it back? The department's attorney said, sure, that's how we like to work these out. Send it back. And he procedurally was able to get it in front of you. One thing I did think, and you heard me say this in that case, was I thought the fact Mr. Conlon had not sought a stay pending that appeal showed good faith on his part. It showed me responsibility that he understood he was revoked, and he understood it was going to be up to you to give him his license back. But again, we don't have that appeal here within 30 days. So now you're stuck with administrative finality, and the standard for administrative finality is not just some substantially changed circumstances, which don't exist here. There's a lot of problems with what the department communicated, but none of that is legally. This is why people hate lawyers, but legally, none of that matters. The dates are the dates. What happened is what happened. The orders are the orders. Does he have, in my opinion, a hell of a good case on his reapplication? Yeah, probably. If he reapplies, I think when you look at all of this, you're certainly going to have a lot of discussion about what's appropriate to do for this fellow. But that's on a new application. That is not on this case. Had revocation been permanent and there was no opportunity for reconsideration, you could have stretched under the, and again, this is really a heavy bar, but you could have under those circumstances said, okay, well, the circumstances are different and it's in the public interest to give this guy a rehearing because otherwise he's going to be permanently barred from practice. And that's just not going to be in the public interest. But that doesn't exist here. He can reapply tomorrow, just like Ms. Lewis could. So again, you could hear from more argument, but nothing I've heard changes my mind. And my advice to you, as the commission, is that you should reject the motion for rehearing, for reconsideration.
All right, thank you, Mr. Harris. Mr. Barber, you're one of the attorneys and my fellow other commissioners from the industry. Does anybody have a question for Mr. Harris of why we should deny the rehearing?
If I may, Madam Chair, this is Commissioner Barber for the record. If I may, Madam Chair, this is Commissioner Barber for the record. He asked a question at the end. He said, really, for the benefit of Mr. Ruiz, he asked the question at the end. He said, if I recall correctly, he's like, I hear the objection from the department. I'm not sure I understand the basis for the objection. I don't want him to leave the hearing not understanding. Although, in my view, there are a few people in this business that do a better job of explaining things than Larry Harris. But just in case it didn't come through for some reason, Mr. Ruiz, the department's basis for the objection is not necessarily on the merits of your argument, okay? It is on the technical and irrefutable nature of your failure to respond. So cases in my business, the legal business, cases go away on two bases, okay? The first basis is a procedural basis. We don't have a preference for that. In fact, we don't like that. And the other basis is on the merits, okay, like what we call an adjudication on the merits. The law prefers that we adjudicate cases on the merits. However, the law will adjudicate cases on the basis of procedure. And on this one, you have great arguments, but it's like, imagine showing up to the courtroom a month after, or in this case, a year after the day you were supposed to be heard. Like, you're going to walk in with the best arguments in America, but there's nobody there. And not only is there nobody there, but there's no way to bring people back in, right, and redo that opportunity. So the reason why we're not going to have a choice, and I want to make sure you understand that, okay? If we went rogue, kamikaze, and we're like, you know what? This guy's the nicest guy, and he has the best arguments, and Larry, I hear you, but I don't care what the statute says. We're going to do whatever we want to do. We just can't do that. That kind of cowboy thing, like, you see it a little bit in D.C. now, and you see it on TV, but other than that, it's not really the way it works. So there's nothing that we can do to solve this problem for you today. What I have heard Mr. Harris say multiple times, and I, as one commissioner, am inclined to agree with, is that if you go through the hassle, and I'm sorry, after 40 years in the business, in 1983, I was 5. Okay, so you were a broker and I was 5. Good for you. Okay, that means you've done a good job. If you go through the hassle of reapplying, when you come to us, again, who knows what's going to happen that day, but it's probably going to work out for you. Today, it can't work out for you. Not because we don't like you, not because we don't agree with you, not because we don't hear you loud and clear, but because we are powerless to give you the relief you're requesting. We just can't do it. We don't have the authority. So I just want to make sure you understand, the posture of the commission and at least the position of this commissioner as to why we can't, do for you what I think many of us would like to do.
And you know what, Mr. Barber, you have done such a good job. And Mr. Rees, I hope you've heard our Office General Counsel,
like
our attorney, and Mr. Barber loud and clear. I think they've done a great job. Hold on just one second. And I appreciate all of your help. This is a great learning case for all of us. Mr. Ruiz, do you want to have a closing 1 or 2 minute comment, and then we're going to vote?
Before the final order was actually executed, I sent a detailed email to the DBPR Council and staff formally requesting reconsideration and an opportunity to respond in reference to all this. And everything just went, nobody would reply to me. So, the efforts that I have been putting to avoid this point, and again, as you all know now, I've been doing this for a long, long time. This is what I do for a living. It baffles me that, and I understand the technicalities as what you're attempting to explain to me, but I think there's a lot of other technicalities that are not being considered that were not on my part, which I've documented, as Mr. Harris has said, and therefore I think it's not so much my error from what if I understand you correctly, that you're stating that I didn't do things timely, I think is the proper word, the legal word. But I have, because again, before the final order, I was already reaching out to your department to avoid the final order.
I know, man, but
Okay.
listen, I don't want to interrupt you if I can, Commissioner Price, because I really want him to understand, because I think he's a good guy. Listen, the problem with that, okay, is that the email, you're sending an email to the department is not the way you respond. It's not correct. Like, you've been doing this a long time. So I'm sure you know that, like, for example, the contracts that I'm sure you've put your clients into a zillion times have notice provisions, right? You're going to lease, somebody's going to sign a lease, somebody's going to sign a contract. There's a provision in there that says notice. And it says, if you have to give notice under this agreement, here's how you have to do it. You have to do it in writing, and it's got to be certified mail, and it's got to be sent XYZ, and blah, 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 and it explains exactly how you give notice. Now, if you have you're in that contract and you have an issue, and you want to notify the other side of the issue, and you don't go to that express provision to look at how notice needs to be sent, and you say you send emails or you send text messages. Listen, the other side in that instance would be entitled to ignore those text messages and emails and actually not respond, because your method of notification does not comply with the quote rules, which in that instance, in this example, the rules are the contract. In the context of this proceeding, of your proceeding, the way to interpose these objections that you're describing to provide this information is not in the email that you sent. So even if we concede, yeah, of course you sent it, you have the proof, here's the email, it was 3 days before the hearing. That is not proper. Like, you didn't do it right. And so I get it, but unfortunately, like I said, this is one of those technicality related problems. Okay. And you just, again, we don't have the authority. Like, we just don't do it. We're not ignoring the technicalities that you're describing. It's just that those technicalities aren't any good, right? Because they don't comport with the rules. So, and by the way, that's why people spend money to hire guys like me, because I had the displeasure of going to school to read about things like that and knowing how to do that, right? I don't expect you to know, but you know, you can't come here and say, no, I did it. I did what I had to do, because unfortunately you did not.
Well, I think, Mr. Barber, I think that we've given a good explanation. I think we've had good counsel from all of our participants. So would you like to make a motion?
I move sadly to deny the relief requested.
I second. I sadly understand that. And so, Butler, is that you?
Yes.
Yes, thank you, Commissioner Butler, for the second. So we're going to take a vote now. All those in favor of Commissioner Barbara's motion and second from Butler, say aye.
Aye.
Aye. Anybody opposed? Thank you so much. For the record, the motion was denied.
Thank you. At this time, Commission, if we could